Welcome to the Retzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Erica Adler, shareholder and leader of our healthcare practice at Retzel and Andrus. And today I am joined by Paul Hales, who is an attorney from the Hales Law Group, and he specializes in health information privacy. I'm really excited to have you on today, and I want to explain a little bit about your background. So welcome before I jump in.
Thank you. Nice to be here.
So I find Paul to be absolutely fascinating. He brings an angle to HIPAA and patient privacy and information privacy that we've never explored before and that I am actually not fully familiar with. And essentially, Paul's practice focuses on providing information and guidance, not only in the United States, but internationally as well, to providers as well as those that do business with providers, so business associates, healthcare plans, and others who need to comply with HIPAA and healthcare privacy regulations. And I know I'm speaking very broadly here, and Paul will go into a little bit more detail. Basically, what Paul does is he provides HIPAA legal consulting and education services to these clients and to anyone who calls himself a covered entity or a business associate. And today, what we really want to talk about, since this is a huge topic, so we could have many, many hours of conversation about this, is really about technology and how changes in technology have impacted whether you are or are not compliant with HIPAA. And I know Paul has some feelings about who's really compliant when they say they're compliant, and some of the things that you may be doing in your own practice that makes you no longer compliant, and you may not even be aware that you are not meeting HIPAA requirements, privacy requirements, state and federal, and those that you're doing business with, even though they have put themselves out there as being HIPAA compliant or meeting all the technology requirements. Are they really? And this is really going to be an interesting discussion about the impact of technology on privacy within healthcare practices and those that you do business with. And I really kind of want everyone to really understand and take away from this discussion what you need to go back and question about your own day-to-day operations and those that you're doing business with. And I'll just kind of turn this over to Paul, but I kind of want to mention that a lot of people that I work with think that they have HIPAA compliance plan. They've had somebody come in and certify them as meeting all the technological requirements. They do business with big billing companies or other third parties who have told them that they're HIPAA compliant and have signed a BAA. And then we all assume everything is good and we're compliant with the law. But that absolutely may not be the case. And it's pretty scary for me to think about, and I know it will be for you as well. So Paul, welcome, and please, enlighten us on this topic because I know you have a lot to say.
Well, thank you, Erica. I do want to talk about privacy and the fact that privacy, and in particular health information privacy, is at great risk today. I do want to pick up on something that you just said, however, before starting on that, and that is that you said that organizations have people who come in and certify that they are HIPAA compliant. The Federal Trade Commission has suddenly become the sort of the most active primary federal regulatory agency focused on health information privacy. And one of the things that the Federal Trade Commission has made quite clear is that statements on websites such as we are HIPAA compliant, or also organizations that provide a seal of HIPAA compliance are committing a fraudulent and deceptive practice that contravenes the Federal Trade Act. And that's new. It's new that the Federal Trade Commission has jumped in They have had three major actions that culminated in consent orders involving health information privacy, where the organizations called GoodRx, BetterHelp, one that had a program called Pre-Mom, were actually collecting and selling health information data for commercial purposes. So that is something that's new. And in doing so, the Federal Trade Commission, much more so than the Office for Civil Rights, that's the office within the Department of Health and Human Services that administers and enforces the HIPAA rules, the Federal Trade Commission is really the primary government agency enforcing health information privacy right now, and it has a health breach notification rule, and it has a proposed new amendments to the health breach notification rule. Another enforcer of that protection of patient health information privacy has become the plaintiffs' bar. And they've jumped in following the Federal Trade Commission, and there are literally hundreds of class action lawsuits pending now for breaches of protected health information related to technology, as you said. And, we live in a world of technology now, and as technology develops, it begins to be used, but only as it's being used, do we understand the implications of the use of that technology, the ethics that are involved, and the need to provide some regulation as to how the technology is used, when it transmits, maintains, creates, receives health information. I think it might be helpful to start with the definition of protected health information, because it really begins with the definition of individually identifiable health information. And that goes back to the original law passed in 1996, the Health Information Portability and Accountability Act. And that law it requires the Department of Health and Human Services to make regulations to protect the privacy and security of individually identifiable health information. So the way that HIPAA defines protected health information starts with the definition of health information that identifies a patient. And one of the first things that was done in the rulemaking process was to determine what information identifies a patient. It's the information that you give to a physician, for example, when you come in for the first time. You give your name, address, things of that nature. But there was the government called together a group of experts in personally identifiable information, and they created, during the rulemaking process, which was a very inclusive and open process, a list of 18 separate pieces of information that are called identifiers that were published in the Federal Register that are part of the HIPAA privacy rule. So there are 18 individual identifiers, and what makes them protected health information, what makes them individually identifiable health information, is when an identifier is related to the provision of healthcare, past, present, or future healthcare, payment for past, present, or future healthcare. And that is something that's widely misunderstood, because most folks, civilians, patients, as well as a number of people involved in the healthcare industry, think of protected health information as information about a diagnosis, a procedure, a prescription, something of that nature. But actually, when you look at the 18 identifiers, they include things like a license plate. Now, when I looked at that, I thought that that doesn't seem right. And then I realized that my optometrist has a freestanding building, and when I park my car in front of the building, my license plate identifies me. That's information that can be obtained. And I am identified as a patient of my optometrist. The Inspector General of the Department of Health and Human Services has an excellent website about the problems related to medical identity theft. And one of the things that the Inspector General makes clear is that only two things are needed by a criminal to identify a patient, to make a patient a target for medical identity theft. And those are the identity of a provider and the identity of the patient. And we see all over the internet patient identities connected to providers. Now, that is a problem, and the FBI has identified medical identity theft as the sort of the gold standard for identity thieves. It's the fastest growing form of identity theft. And the reason it's the gold standard is that it brings the most money on the dark web, on the very active black market for medical identity. And the reason it brings so much money is that it's used to commit health insurance fraud and to obtain prescription medications. And people are not aware that their medical identity has been stolen until, for example, they receive an explanation of benefits that says that they owe several $100,000 for a hip replacement that wasn't pre-authorized, but they never had the hip replacement. It was obtained by somebody using their medical identity. And it's not only a financial issue and an issue that is very time-consuming to straighten this out with the health insurance company, but it's also a patient safety issue because we have a system of electronic health records, health information exchanges. A person who might use my medical identity might have a different blood type than I have. And if I needed emergency care, why, I might receive a transfusion of blood that was of a type that belonged to the person who used my medical identity, and that can be life-threatening. So it's also a patient safety issue. Erica, I don't want to get carried away with this. I really want to
There's so
talk
much
about,
interesting information. I guess what I would want to know is, we know what PHI is, it's out there, and what kind of things are practices and other healthcare providers doing wrong or not maybe aware of when it comes to technology, and how they may be collecting this information improperly, sharing this information improperly, or may not even realize somebody else is taking this information from them. And I think that would be a really interesting direction, so they can understand how they're personally involved in this potential misuse that's occurring.
Sure. Let's talk about something that's brand new. It was first discovered in 2022, and that's the use of tracking technologies on websites, healthcare provider websites, health apps, and the tracking technologies are really everywhere. And so, speaking directly to people who are watching this video podcast, if you are a healthcare provider, the likelihood is that you have tracking technologies on your website and on your social media websites that identify patients and transmit, or what the HIPAA rules call disclose, protected health information to third parties, people who are not authorized to have that information. And one of the things that the Federal Trade Commission was focused on in the enforcement actions that I mentioned earlier, GoodRx and Better Help, was the sale of that, or the use of that identifying information so that it could be sold to advertisers or used by advertisers to target people. The assault on privacy continues apace, in part because people themselves share so much information. But it's the covered entities, it's the healthcare providers, it's the health plans, it's the business associates that serve covered entities and require protected health information in order to provide those services, like billing services or coding services, things of that nature. And what happened in 2022 is that an article was published on an online a magazine called The Markup. And the title of the article was, and I'm approximating it, but it was that hospitals are sending protected health information to Facebook. Well, that set off a firestorm. And hospitals, and what was happening was that Facebook had something called a metapixel that was present on hospital websites, even present within patient portals. And the metapixel is a small piece of code that identifies a person and can also identify not just the person and the provider, but when it's within a portal, it can provide some very, very specific information about the healthcare that is being sought or provided to the patient. Well, what happened next was hospitals began to examine their own websites, and then realized that that these tracking pixels caused breaches of unsecured protected health information as defined by the HIPAA breach notification rules. So they reported those breaches to the Office for Civil Rights and began to send out breach notification letters to inform patients who were affected by this breach that their information had been disclosed through the use of these tracking technologies. The two key types of tracking technologies that are under most scrutiny by the regulators are the metapixel, which comes from Meta, formerly Facebook, and Google Analytics. As soon as those letters came out, I'll give you an example. One of the hospitals was the Advocate Aurora Health System. And it notified on October 14th, the Office for Civil Rights, that as a result of these tracking technologies, the protected health information of 3 million patients had been disclosed to unauthorized entities, namely Facebook and organizations that obtained information about the patients from Facebook. That was on October 14th. October 20th, Advocate Aurora Health began to send out the notifications to patients of the breach. On October 28th, the first class action lawsuit was filed against Advocate Aurora Health. Now, a number of class actions were filed, consolidated, and they were just settled rapidly. But the proliferation of class action lawsuits based on tracking technologies is growing dramatically. And the thing about most web-based breaches or violations of HIPAA is that they're out on the open. In other words, people respond to patient reviews by thanking the patient for reviewing. Well, what does that do? It identifies the patient as a patient of that healthcare provider. That gives the information to the criminals. That makes the patient a target for medical identity theft. But the thing about these tracking pixels is that they're not obvious. They're not out there so that you can see them on the internet. However, they can be found, and they can be found very easily using some widely available software. One of the types of software is called Web X-ray. So in April of this year, 2023, an academic journal article was published by academics, physician, lawyer at the University of Pittsburgh. And they found that 98.6% of hospitals had these tracking technologies. And the article makes it clear that the hospitals didn't put those on to do any harm. I mean, they're on there for several reasons. One is that organizations have so many different actors involved in things like marketing, creating websites. And by the way, a Facebook web page is really a website that's as defined by federal law. And Facebook knows that it's a website. You can see that when you read their terms and conditions of use. And so if a provider creates a Facebook web page, they're doing so under the terms and conditions of creating a business page by Facebook. Facebook says, we're not charging you anything for this, but in order to use it, you must give us certain permissions. Well, the courts have held that that is, in fact, a contract. And the definition of a web page in the HIPAA privacy rule it's in the section about notice of privacy practices, where it says that a provider that maintains a web page that provides information about their products and services must post prominently on the web page their notice of privacy practices and make it available electronically through the website. And that's a definition of websites that are governed by HIPAA. So one of the things that we see is only a few healthcare providers have begun to put their notice of privacy practices on the Facebook page. Again, I'm kind of going off the...
No, not at all. I guess, look, there's obviously some hospitals that have figured out that they disclosed information that they shouldn't have because of this, metapixel or whatever it was. But wouldn't that also mean that every single practice out there that has a Facebook page, or, is, you mentioned Google as well, having something equivalent. I mean, there's some class action lawsuits because those are big providers. But what about all the other ones? I mean, does that mean that do they just not know, or they're too small and nobody cares, or is it really everybody that's violating it right now?
Actually, everybody is violating it right now, and I'm most concerned about the small organizations. What they do is even large organizations hire marketing companies that say that they specialize in creating web pages or Facebook pages that engage patients, that attract new patients, that help communicate the quality of the healthcare services that are being
Right.
provided. Those are marketers. They're terrific at marketing, but it's their customer that's responsible for complying with HIPAA. Now, Google has posted and made it very clear that they will not sign business associate agreements with organizations that have Google Analytics on their websites. And Facebook has in its terms, as does Google, the admonition to not send us any protected health information. But it's happening, and it's happening really without the knowledge of most of the healthcare providers. Now, the large hospitals that recognized the issue began addressing it by auditing their website, finding the tracking technologies and removing them. However, and then what happened on December 1st, 2022, is that the Office for Civil Rights issued a bulletin that says that having these tracking technologies can violate HIPAA by disclosing protected health information of patients. Now, that was December 1st of 2022. The American Hospital Association responded forcefully on May 22nd of 2023 with a letter complaining about the December 1st bulletin, and in particular saying that an IP address, which is one of the 18 identifiers and has been in an identifier in the privacy rule since it became effective in 2003, should be removed, that it shouldn't be considered an identifier. Well, you know, your organization has one of these video casts explaining how you identified a person who made very defamatory and apparently anonymous comments about an orthopedic surgeon.
Right.
And how did you identify that person? Through the IP address. So
Yeah.
it is certainly one
So
of the
so that happened in May 2023. It took them actually quite a while to respond. Well, where do we really go from here? I mean, for the people listening, obviously this ongoing issue for most of them, they're smaller parties. They're probably watching it, or they will start watching it play out now amongst the hospital systems. Should they not be on the web anymore? Should they not be using Facebook? Really, how can you protect yourself now? Most practices are not sophisticated enough and to find this technology, this tracking software. They're hiring people who hold themselves out as having the knowledge and capabilities, but this sounds so sophisticated that I would bet many of these technology companies that they work with lack this actual expertise. So really, is it safe right now, I guess, is the question, to be using the internet, to be using web pages and Facebook, or is it just a common risk that we're all sharing while we figure things out, I guess, is the way to think about it.
So I'm going to answer that question. Every organization, small, large, should immediately identify and remove the tracking technologies from their website. I need to give you one more piece of information, and that is that in July the Office for Civil Rights and the Federal Trade Commission jointly sent a letter to 130 hospitals advising them that the tracking pixels that were on their websites were violating HIPAA and the Federal Trade Act. And then a few weeks later, they made public all of the 130 hospitals and some telehealth organizations that received those letters. So the resounding response to the American Hospital Association's complaint was that the Office for Civil Rights and the FTC together doubled down and said, no, this is a problem. So what we see on Facebook and on Google are links that tell you how to remove tracking pixels from your website. Now, these are installed without thinking by the web developers. And if you're a website for, let's say, a salon or a car dealer, well, they're very, very useful. But if you're a website, a healthcare provider or a health plan, you've got to protect the patient privacy. Now, when we look at the instructions that are provided by Facebook and by Google to remove the tracking technologies, gosh, they're kind of complex. So and you're right, people, with their, I think oftentimes, for example, my dentist had his Facebook page set up by a staff member who was a young person who was really familiar with Facebook, but was completely unaware of the problems associated with allowing posts and reviews on the Facebook page and so forth. So what you need to do, whether you're a large organization or a small organization, is do an audit, and you've got to put together a team to do that. And it's an inclusive team. So it's a team that includes some information technology specialists, and you probably have one who, even if you're a small organization, who's maintaining your information technology. Include your compliance officials, legal counsel, marketing, and make sure that senior management's involved. They're the ones that are responsible. The senior management may delegate authority to create a HIPAA compliance program, a privacy official, a security official that develops and implements the program, but they can never delegate responsibility. And it's senior management that needs to be involved, and any others. Now, that's something that any small organization can do. You've got the wherewithal, and it's something that should be done right away, because while the American Hospital Association is complaining and fighting this interpretation of the privacy law, privacy rule by the Office for Civil Rights, they have yet to complain directly about the Federal Trade Commission. The Federal Trade Commission is really becoming very, very active. And also, state attorneys general. Just a few weeks ago, 49 states and the District of Columbia settled a major suit against a business associate, Blackbaud, that provided services to nonprofits, including healthcare providers. So there's a lot of regulation going on, regulators who are catching up with the technology.
Right. I guess, one question, and then we probably need to wrap this up, is, they came up with a list of all the hospitals that they felt were violating it. And so they seem to be targeting hospitals right now. Do you anticipate that they're going to start targeting healthcare practices as well, or other types of healthcare organization? Is this something that is likely to occur? Or do you just feel like they're going after the biggest targets and hoping to send a message?
The Office for Civil Rights has limited staff. Plaintiffs' lawyers have an unlimited reign, and they can use these tracking technologies to identify, or the things like Web X-ray, to find out if providers have the trackers on their websites. Now, even a small practice has thousands of patients. And so each one of those patients can be a member of a class.
Wow.
The way that organizations that really come to the attention of the regulators is twofold, primarily. One is that complaints are made, and the other is that there are breaches of protected health information. Now, with the growing awareness of the violations related to tracking technologies, I suspect that we're seeing a growth in complaints that to the Office for Civil Rights and to the Federal Trade Commission. That hasn't been made public. However, there would be incentives to make complaints that your protected health information has been disclosed. Not only incentives that are caused by your own worries about having your medical information compromised and in the hands of criminals, but also opportunities to make some money as a result of making a complaint.
Wow.
We're really dealing with a clash. It's between laws that have been developed to protect the privacy of patients and consumers, and activities that abound on the internet that are built on individually identifiable information as a commercial enterprise.
This is a fascinating topic. I think I have a million more questions, and I know we didn't even talk about artificial intelligence, which I know is another area that you have a lot of opinions and information on. So I hope you'll come back and talk to us a little bit more down the road. I encourage everyone listening to this to take to heart the advice that was provided. Reach out to Paul directly with questions or guidance if you think that you are doing something wrong, you're not sure how to address it, and you're building that team, which includes your legal team. This is his area of expertise. And if you have questions or concerns, reach out, and obviously I'll try to help as well, but Paul is much more the expert in this area than I am. And his information will be shared when we post this podcast. But this is really just a fascinating topic. And thank you so much for joining us today.
You're most welcome. It's nice to be with you.
Great. So everyone out there, this is the Health Law Hotspot. You'll be able to catch this podcast as well as our others at ralaw.com. And I hope you'll join us next time. Thanks so much.
The Retzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Retzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Retzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.